Hello, everyone. Thank you all for coming to the California State Library's webinar on cannabis in California, an overview of federal and state laws. My name is Michael McCurdy, and I'm a librarian at the Witkin State Law Library, part of the California State Library, and I'm the host of tonight's event. Before I introduce our guest speaker, I have just a little bit of housekeeping to cover before we get started. We have two co-hosts tonight, Vanessa Chrisman, the principal librarian of both the Witkin State Law Library and the Government Publications Library, and Garrett Shields, a librarian from the Witkin State Law Library. The chat feature will be turned off for tonight's event, but we will have the Q&A feature open where you can submit questions for the guest speaker, which will then be read aloud during the Q&A session at the end of the presentation. If you experience any technical difficulties, please enter those in the Q&A window and we will do our best to help you. Live transcription is also enabled, so if you'd like to see captions, please click the CC icon in the toolbar to show subtitles. And this talk will also be recorded. To get notified about the recording for this event and to stay up to date on the Law Library's happenings, please subscribe to our quarterly e-newsletter on the State Library's website. And Garrett has just put a few links in the chat window that you may all find useful. The first is for the State Library's homepage. The second is where you can sign up for our mailing lists and newsletters. And the last is for our Ask a Librarian reference platform, where you can submit research requests on any topic, not just the law. I also briefly want to talk about the State Law Library. For those of you who are not familiar with us, the Law Library provides free legal research assistance to anyone who needs it, regardless of where you live. Our specialty is in historical California legislative and regulatory research. And if you need any assistance finding historical legislative bills, statutes, regulations, or you have any other type of legal research request, including anything cannabis law related, please don't hesitate to reach out to us. Our extensive collection of international, federal, and all 50 state legislation allows us to help users conduct a wide variety of legal research outside of California's borders. The State Library also has a government publication section that collects federal and state agency reports, maps, and a plethora of other government documents that can be useful to legal researchers. I also want to touch upon some areas of our service limitations. We do not have any attorneys on staff, and we are librarians and not lawyers, so we cannot give any legal advice or interpret any laws. We also don't offer any legal aid clinics, but if you do need legal advice, let us know, and we can help with referrals to legal aid organizations. For any research needs you have, legal or not, you can visit the State Library in person, Monday through Friday, 9:30 a.m. to 4 p.m. You can give us a call at our reference desk, you can email us, or you can submit a request online via the State Library's website by clicking on the Ask a Librarian icon in the upper right-hand part of the page. And here you can provide your contact information and your question, and one of our librarians will get back to you and respond to your inquiry. So a quick note about tonight's webinar. It was created to discuss cannabis laws and their evolution, and it's not going to be a moral, medical, or philosophical discussion about cannabis, nor are we able to answer any questions about the legality of any actions you may take. And events like this would not be possible without the help of the California State Library Foundation, so a big thank you to them for helping put on this webinar. And now that housekeeping is out of the way, let's get on to the main event. Our guest speaker today is Professor Michael Vitiello from the University of the Pacific McGeorge School of Law here in Sacramento. Professor Vitiello is the author of 13 books and over 80 law review articles and has been cited by 2 Supreme Court justices. With that, please give a warm virtual welcome to Professor Vitiello.
Okay. All right, Michael, should I go ahead and start?
The floor is yours, Professor.
Okay, so I've got to clarify something initially. To some degree, I guess I'm an expert on marijuana law. I'm co-author of a casebook on marijuana law that West Academic Press has published. I've been writing about marijuana law since the late 1990s. I just am back, though, from a symposium on marijuana, cannabis, drug policy generally, a symposium at Arizona State last week. And one of the things that occurred to me as I was in that room was that none of us really can claim to be an expert about marijuana law. It is too diverse an animal for any human being to become an expert in the entire complexities of marijuana law. Let me describe that in another way to get at the same point differently. A year ago, I was co-teaching a seminar on marijuana law here at McGeorge. I was teaching it with a young friend who is in the industry. And I realized very quickly that he was teaching and coming at it from a completely different perspective from mine. In fact, I had never seen students excited by corporations or business organizations. When I was a student many, many years ago, I certainly did not get excited by corporations. Lo and behold, my students, when we were doing a simulation exercise on forming a marijuana business, my students were all over it. What we have done here at McGeorge is now to divide our marijuana law into two distinct courses. We're either the first or second law school in the country to do so. I call myself Marijuana Law 1.0, and I'll describe my course and the issues in my course and the issues that really excite me in a little bit. That's the gist of my remarks today. But our course now, I also include drug policy generally for reasons I'll explore a little bit later. But my friend teaches the business of marijuana law, and he does things like taxation issues, licensing, business formation. How are you going to fund it? How are you going to organize your business entity? Very hard to be an expert on all these different fields. So let me start with one of the issues that many people in the public don't realize. And sometimes with a great deal of personal cost as a result. It's a little bit of a misnomer to say that marijuana is legal in California. You know that Prop 64, quote unquote, legalized recreational marijuana in California. And you know that Prop 215 back in 1996 legalized medical marijuana. Virtually all use of marijuana violates federal law. Sometimes people, rather tragically, learn that the hard way. One of the things that there was a person, who presented via Zoom when I was at the symposium last week, a guy named Luke Scarmazzo, I think is how he pronounces his name. He was many years ago, in 2004 or thereabouts, he opened a California licensed medical marijuana dispensary. And the federal government closed him down, charged him not only with violating the Controlled Substances Act, but also a criminal enterprise statute. And he was given a 22-year prison sentence. You would imagine someone like that just stunned that he thought that he was complying with state law, and suddenly he was violating federal law. Very brief history. Richard Nixon, when he was the president, began the first war on drugs. It was during the late 1960s and eventually 1970 when the United States created the Controlled Substances Act. Part of it was very sensible. We had 200 laws regulating legal and illegal drugs, and we needed to develop a scheduling system and the like. But for those of you who are my generation, I don't know if there are any old timers out there, but the 1960s were a period of time when there was a lot of experimentation with marijuana. And public sentiment was really deeply divided on whether marijuana should be legalized or not. During the process of creating the Controlled Substances Act, the federal law that governs scheduling marijuana, for example, during the process, there was a sticking point. There was a dispute about how marijuana ought to be treated. The compromise was that President Nixon would appoint a commission to study what should happen with marijuana. And in the interim, marijuana was listed as a Schedule I drug, and it's still there a few years later. A Schedule I drug is one without any recognized medical use. The idea was that everybody thought, who was a party to the compromise, thought that the commission report led by Ray Schaefer, well-respected former governor of Pennsylvania, that the federal government would follow the recommendations in the Schaefer report. When the Schaefer report recommended getting rid of making marijuana, basically decriminalizing marijuana, Nixon ignored it. And ever since, marijuana has been a Schedule I drug. So the effect is, when you go back to my example about the person who is running a dispensary in California, for example, or Colorado or Washington or many of the states around the country, in theory, they're violating federal law and could be subject to very severe sanctions. I'll talk about some of the reasons why many dispensaries are still open without federal prohibition, but that's another issue. First issue I want to then turn to is, again, there are some lawyers in the audience, I think. I want to talk to you about the fascinating ethical issue that lawyers face who want to practice cannabis law. Some of you may know that a lawyer is not allowed to help her client violate the law. So what happens in California if you have a client that has a piece of real estate and the client wants you to write a lease so that the property owner can lease it to a marijuana dispensary? Well, in theory, you're violating federal law. So how can you do it? Well, the problem arose all over the country. Different bar associations around the country issued opinion letters and the like. And in the early examples, bar associations said that a lawyer could not help a client organize a business, even in a state where medical or recreational marijuana was legal. Then basically, it obviously violated federal law, and you're not allowed to counsel your client to violate the law, to assist him. When you think about the technical problem in such a case, you can start to understand why the trend started to change about 5 years ago, or 6 or 7 years ago. It's not quite important when it started to change. Think about states that have, like California, where you can open a business complying with California law. You want to open a business, California regulations are ridiculously elaborate, extremely expensive to comply with, by the way, one of the problems with Prop 64. But imagine having a layperson trying to figure out how to comply with all of California's regulations. States started to recognize that the state has an interest in having people comply with the law. And so the modern trend has been to say that lawyers are allowed to assist clients in organizing business consistent with state law, as long as they do something. And that something is that they have to advise the clients that the conduct violates federal law. It's a little bit trickier too, because they're supposed to advise the client about what the consequences are. And I'll talk a little bit later as well about some of the Reagan era penalties. Nixon made war on drugs, but Reagan ratcheted up the penalties during the Reagan administration. Congress and Reagan ratcheted up the penalties available to marijuana offenders. But back to the lawyer advising her client. You've got to tell your client that, yes, what you're doing legal under state law, but it violates federal law. And in theory, you're supposed to explain the penalties as well, not only the criminal penalties, but also the possibility of forfeiture and the like. Pretty chilling conversation if you have that conversation without explaining a little bit of the background about why marijuana businesses have been able to open successfully without a lot of federal interference. But that's another story we'll get to in a little bit. One thing that remains somewhat iffier, more controversial, so the lawyer can sit down and draft instruments, contracts, leases and the like, can file papers on behalf of the client. A little bit trickier is whether the attorney should take an ownership interest in a marijuana business. I talked to people in the industry, and one problem with many clients in the industry is they have limited access to capital. And so very often what they want to do is to swap ownership interests for legal services. And some lawyers are doing it. I think it's a little bit iffier than merely drafting instruments and the like. In theory, though, being involved in the industry represents a serious criminal risk in theory, not so much in practice, for reasons I'll get to, but as a person who aids and abets a criminal enterprise, which again, in theory, marijuana businesses are, is fully responsible for the underlying crime. Reagan-era penalties for possession, distribution of large amounts of marijuana are severe. In theory, probably unconstitutional, a drug kingpin could be subject to the death penalty. But there are life imprisonment sentences for very high distribution of marijuana. So again, these are legal issues that lawyers in the cannabis area have to negotiate. They have to decide how much risk they want to take, how realistic the risk is, and the like. But I thought that would be a good place to start thinking about how complex this area of the law is. How can lawyers take the risk? Well, that too is, at least for those of us in the field, is a fascinating question. Back in the George W. Bush era, the federal government commonly raided marijuana dispensaries. And in the 2008 presidential election, then candidate Barack Obama urged that he would take a kinder and gentler view of state legal medical marijuana businesses. That didn't happen right away. But eventually, his Justice Department issued a memorandum called the Ogden Memorandum, named after the member of the Attorney General's office, Ogden. And basically, the federal policy at that point was that in states where medical marijuana was legal, that the federal government would not intrude if the state would comply with a concrete list of federal law enforcement priorities, making sure that minors didn't get access to it, that there wouldn't be an involvement with cartels and the like. What happened with the Ogden Memorandum was it gave the industry a kind of, the federal forbearance gave an opportunity for capital formation. Investors who had been waiting on the sidelines started investing in industries. States like Colorado and Washington became emboldened, therefore, in 2012 to attempt to pass recreational marijuana laws, which they did. Same thing happened during the post-2012 era. Different attorney general, member of the attorney general staff, Cole, issued 2 memoranda, basically the same thing. If you're in the state where you have recreational marijuana that's lawful, the federal government would forbear prosecution if the state would assure that there was compliance with federal law enforcement priorities. Very briefly, January 4th, 2018, Jeff Sessions, then the Attorney General under former President Trump, announced that the Department of Justice was shredding the Cole and Ogden memoranda. Time magazine called me a couple days later, and I said, well, I didn't think it would have much effect. I said, money is not blue, it is not red, it is green. And that at that point, there had been so much capital flowing into the marijuana industries in states where it was legal that you would not see the federal government cracking down. In effect, that turned out to be true. For the first time, many members of Congress on both sides of the aisle who had been mum beforehand started coming out in defense of state legal marijuana regimes. Subsequently, no, actually shortly before that, and continuing, there has been an ongoing budget resolution, Rohrabacher-Farr, named after the members of Congress who have advanced the policy. Rohrabacher-Farr says that Department of Justice money cannot be spent on prosecuting medical marijuana businesses that are in compliance with state law or substantially in compliance with state law. The point of all of this is to show you how you can have a regime where it is legal under state law, illegal under federal law, and yet businesses are open. In fact, anyone who is listening to this presentation could probably within 10, 15 minutes find a marijuana dispensary not too far from where you live. And the reason is because of these policies of forbearance that have been developed over more than a decade now. Let's see. So let's see what else might be in a marijuana course. After I've laid out the ethical issues that my students may face if they want to practice marijuana law, after I give them the history of the Controlled Substances Act, one topic that we turn to is how the Constitution relates to marijuana. And there's several areas that I think that you'll find interesting. One, Second Amendment rights. There is a provision in federal law that does not allow issuance of a gun license to someone who is a drug user, and that includes marijuana. Now, I think that it's based on the old stereotype back in the days of reefer madness that marijuana drove people crazy into violence and the like. But nonetheless, that is a provision where if someone acknowledges on an application for a gun license that he is a marijuana user, the person is not entitled to get the license. Now, you start to wonder whether that might violate the Second Amendment right to bear arms. Until very recently, the answer had basically, when lower federal courts had considered the issue, the answer had been basically, no, that kind of regulation was actually allowed. That the standard of review that the courts applied was quite permissive towards allowing regulation of weapons under those circumstances. That is almost certainly changing. Last term, the Supreme Court decided a case called Bruin, a case involving New York law, not dealing with marijuana, but an opinion written by Justice Thomas, basically pushing back. He had been arguing for quite some time that the court itself and the lower courts were treating the Second Amendment right to bear arms as a second-class constitutional right. And the speculation now, and there's some lower court opinions already coming out this way, that the federal regulation of disallowing licenses for people who are marijuana users will probably run afoul of the Second Amendment. But again, it's one of those areas where, for those of us who are legal nerds, where we find the interplay of drug laws and other constitutional provisions kind of exciting. Let me move to some other constitutional conflict between the Constitution and drug laws. Back around the time that Prop 215 was passed in 1996, the drafters of Prop 215 had to figure out how, because this was a medical marijuana era, recreational marijuana wasn't going to go anywhere in the 90s. There was a lot of sympathy for medical marijuana, especially with the AIDS epidemic, with cases involving cancer patients. And you'd see grandmothers who claimed that it was the only thing that could help them get through the nausea associated with cancer treatments and the like. The problem with a medical marijuana regime back in the 90s was, because marijuana is a Schedule I drug under the Controlled Substances Act, a doctor cannot prescribe it. A Schedule I drug is a drug for which there is no recognized medical use. Well, what are the proponents of medical marijuana going to do? Well, if you look at Prop 215, doctors can recommend, not prescribe, but recommend marijuana to patients. That recommendation would then allow the patient to go to a dispensary, or if approached by whether dispensaries could be open was another distinct question. But whether, for example, if the police stopped someone who possessed marijuana, the person could show the officer that she had a recommendation from the doctor. Now, is that legal? What happened was quite interesting. It involved the First Amendment, right of free speech. Medical organization, well, the federal government started to lean on medical organizations to give notice to doctors that they were not in compliance with their obligations under federal law if they recommended marijuana. They didn't try to, DEA and the DOJ did not try to bust doctors. That would have been, all heck would have broken loose in the headlines, I'm sure. But there was civil litigation brought, and eventually the Ninth Circuit Court of Appeals rendered an opinion in Conant versus Walters in the early 2000s. And basically it said that a doctor and patient basically have a First Amendment right to discuss the efficacy of marijuana as it might apply for that patient. Is that good marijuana law? I'm sorry, good First Amendment law? We could argue about that. Conant versus Walters became sort of the test case for the rest of the country, an enormously important case, because what it signaled was to the medical profession was that they could safely get involved in recommending medical marijuana. Some of you may remember the Sacramento News and Review. I think that was the name of it. I would occasionally pick up a copy of it, and you would see doctors advertising that they would do examinations and make recommendations for people interested in medical marijuana. And when the proposition was still quite young, the cost of a consultation, which you would have to have every year, was in the $200, $300 range. And as it became safer and safer, when cases like Conant were decided, and the number of doctors then who saw a safe way to make some money, the cost of getting a doctor's recommendation plummeted down into the $40 range or thereabouts. Why? Again, because the First Amendment to the Constitution. While we're on the subject of the First Amendment to the Constitution, I might mention that there are some fascinating issues involving religious freedom. Now, most of the religious freedom cases involve different drugs, not cannabis, not marijuana. You may be aware that some tribal religions use peyote as part of their rituals. There are some other psychedelic substances that are used in a variety of religious contexts. The Rastafarians, by and large, have been unsuccessful in most of the litigation involving Rastafarians, claiming that marijuana is part of their religious rituals. But again, it raises the interface between the Constitution and marijuana laws. More constitutional questions. I mentioned that during the Reagan years, the penalties for marijuana crimes were ratcheted up severely. I mentioned that the possibility of a true life sentence is still on the books. As I say, I doubt the death penalty would be available. The Supreme Court has pretty much said that unless a death results as a result of the defendant's conduct, the death penalty is disproportionate. But true life sentences are available, and very, very long sentences have been dished out for marijuana offenses. What about the constitutionality of such extremely long sentences? Here, I want to describe a case that some of you all may be familiar with. Became a headline case. Many years ago, trying to remember, Snoop Dogg was quite a young performer. This is probably in the 80s. There was a young music producer named Weldon Angelos. Angelos was working with Snoop Dogg and other performers and starting to get a successful business off the ground. On 3 occasions, he was approached by an undercover federal confidential informant. And Angelos, who admits having made marijuana sales in order to supplement the income from his business, he made 3 different sales of about $300 each to the confidential informant. He was eventually arrested. He was tried on many accounts, including apparently there was some debate about, well, one of the charges involved someone dealing drugs who was also in possession of a firearm. And the confidential informant said that Angelos was in possession of a firearm during the drug transactions. Now, I ought to ask you if this were interactive. I don't know if any of my former students are out there, but if this were interactive at this point, I would ask you, what do you think a sentence might be for someone who sold small amounts of marijuana on 3 occasions? Well, under federal law, eventually, Angelos was not convicted on all the charges, and the net sentence was over 55 years in prison for selling those 3 different sales of marijuana. 55 years. The sentencing judge, fascinating judge. He was a law professor at Utah. Then he became a federal judge, and now is back at the University of Utah. Paul Cassell, very prominent figure in the victims' rights movement. Paul agonized over the sentence. I think partly because Paul is a very strong Second Amendment rights advocate for the right to bear arms. But also just the sentence seemed to be obscenely long. He was a father of a couple, 2 or 3 children, just launching his own successful business, and had no prior criminal record, and so certainly no prior criminal record of any violence. 55 years in prison, far longer than, for example, people found guilty of second-degree murder. Well, does the Constitution say anything about such a long sentence? And the short answer is not very much. There is a provision of the Constitution. Some of you may be aware that the 8th Amendment to the Constitution says that the government cannot impose cruel and unusual punishment. And although there's some members of the court who think that applies only to torture, for example, they can't draw and quarter you like they used to do in the old days. probably can't put you in the stocks. But the Supreme Court has held that the cruel and unusual punishment provision does apply to prison sentences. Now, the court's jurisprudence is very restrictive. I mean, there are very few cases where you can actually show that the sentence is so grossly disproportionate. And Angelos lost his argument in the 10th Circuit Court of Appeals. He tried to argue that his 55-year sentence was excessive under the Eighth Amendment. There was earlier precedent from the Supreme Court that a person who possessed 9 ounces of marijuana, who received a 40-year term of imprisonment, was subject to cruel and unusual punishment. The Supreme Court said no, that was not grossly disproportionate. I've argued in an article that I did a couple of years ago that under the Supreme Court's test, maybe as if you look at the way in which society now views marijuana offenses, you might be able to succeed, or at least might be worth trying that argument again in some of these cases involving very long sentences. Angelos was a lucky man. He had a sister who just kept his case in the public eye. He had a couple of law professors, both of whom, a couple of I know, prominent law professors, one at Arizona State, one at Ohio State, who worked tirelessly trying to get his case overturned through legal challenges. But eventually, former President Trump ended up pardoning Angelos. And now he has become a heavy player in attempts at overturning some of these very severe punishments under the Controlled Substances Act. More constitutional law. One of the areas that I like to teach is how the Fourth Amendment to the Constitution was eroded during the war on drugs. And for those of you not familiar with the Fourth Amendment, we have a right to be free from unreasonable searches and seizures. And under certain circumstances, the police need to get a warrant based on probable cause. During the war on drugs, really dating back to the Berger Court, and then really very active, the Berger and then Rehnquist Court, very active in eroding the Fourth Amendment protections that have been built up during the Warren Court era in drug cases. Now, the most common drug cases are, for reasons that I think you can figure out pretty easily, most drug cases have been marijuana cases. It smells, it's bulky, and it's the most commonly used drug. There were a number of areas, well, many areas, but I'll just give you a few examples where the war on drugs got the court chipping away at and eroding Fourth Amendment protections. You've gone through an airport, of course, now because of security reasons, it's less of a surprise. But back in the day, in the 80s, for example, you would see drug sniffing dogs sniffing luggage. And seemingly, under the Fourth Amendment, the police would need probable cause because it looks like a search. They want to find out what you have in your luggage. No, said the Supreme Court, a dog sniff is not a search. Long, elaborate explanation, not all that convincing for some of us. But that'd be one example where the war on drugs led to the erosion of the Fourth Amendment. What about a brief detention on the highway based on a minor traffic violation, and the police want to bring along K-9 unit to sniff your car? Again, not a search. Why? Sui generis. All it does is reveal the presence of contraband. You have no expectation of privacy in contraband. What about racial profiling? You look at the number of cases with Latino names, defendants, Very often you suspect in many of these drug cases that police were engaging in racial profiling. Supreme Court said, oh, no, it's an objective determination. As long as the police had probable cause, often for stopping a suspect based on a minor traffic violation, even if you suspected racial profiling, as long as there were objective reasons to make the stop beyond the Fourth Amendment's protection. Flying over one's home. Anybody who has watched any of those television shows, those raids up in Humboldt County and the like, know that helicopters come swooping in very close to property. Is that a search? So that the police would need some prior authorization? No, that's not a search. You knowingly reveal that to the public and the like. So again, yet another area where the Constitution has an interface with marijuana law. I do want to leave, I do want to leave time for some questions. I do want to mention, though, a couple of more issues. One that is quite interesting today, although I don't think that the current Supreme Court would reverse its earlier decision. During the Bush administration, after California legalized medical marijuana, there were a couple of very prominent medical marijuana advocates who grew or had someone grow small amounts of marijuana entirely within California. And after they were raided, they brought a federal civil rights action claiming that the Controlled Substances Act, as applied to them, violated the Commerce Clause. Congress is given the power under the Commerce Clause to regulate interstate commerce. And their argument was this is entirely local and it has no effect on commerce. In Gonzalez versus Raich, the Supreme Court said, no, indeed, using some early cases in the Roosevelt era that expanded federal power by using the Commerce Clause, the Supreme Court said, no, that even small amounts of marijuana grown entirely in state for consumption within state could eventually have an impact on the interstate market, and therefore Controlled Substances Act prosecutions against small in-state medical marijuana growers constitutional. Now there's an interest on the part of some members of the current Supreme Court to invigorate, to narrow the Commerce Clause, but whether we would see a reversal of Raich, I'm not sure. Oh, there's so much more. What about forfeiture? Grandma and grandpa let their grandson live with them. He grows a little bit of marijuana in the backyard, and the police come, they raid the place, and now they want Gramps and Grandma. They want their house. To what extent can the government forfeit property when that property is used in drug transactions? I'll just let that issue stay out there. There are some limits on what the government can do. There have been some very famous cases of strong arm tactics by the police. Police love to get forfeiture because that way they can get the forfeited assets and buy toys for their police departments. But there are some limits to that. Well, let me fast forward to the present time. Some of you may be interested in knowing what President Biden has been talking, what he said about marijuana. Many of us know that Biden is hardly a marijuana law advocate, partly generational, partly temperament. But one of his pronouncements was about rescheduling marijuana. get the federal government to make it some lower schedule, so that either there could be some prescription by doctors. But the long and the short of rescheduling is, many of us in the field question the wisdom or whether it would really make much difference to try to reschedule marijuana. Dating back to the Nixon era, I mentioned earlier the Schaefer Commission report, and the federal government has vigorously fought rescheduling marijuana. But part of the problem now would be there are a lot of red tape that you need to go through, unless Congress was simply to reschedule marijuana. But for example, to get the agency to reschedule marijuana, you're going to have to show, for example, dosage, and there are other technical requirements that may make it more expensive than certainly anybody in the medical marijuana industry really wants to engage in that kind of process. The only way the big players in the field, big pharma, for example, might be interested in, as they have been in a couple of products. There's one product that now is FDA approved, and it's an extract that allows treatment for seizure disorders. But that's a drug where big pharma was able to reduce it to a kind of a dosable amount of a drug and extraction from the plant. But as a general proposition, whether rescheduling is worth the time and effort is open to serious debate. There is one other thing, though, that's quite fascinating in the rescheduling debate. Rule number one: if you want to get a drug rescheduled at Schedule 1, you have to show that there is medically accepted use for that drug. For most of the history of the Controlled Substances Act since 1970, when the federal government allowed research projects into marijuana, the research model was showing the ill effects of marijuana. And so researchers who wanted to show the medical benefits of marijuana had a heck of a time, if they were able to at all, do research to show the good medical benefits of marijuana. Today, there are tons of people who swear by medical marijuana products. I went to a retirement community with my beloved mother-in-law, and there was a young doctor, she was in her 50s, talking to a group of geriatric people sitting on the edge of their seats, interested in medical marijuana. Why? Well, CBD helps sleep, pain medication, and the like. So despite the very powerful industry that believes in the medical uses of marijuana, whether rescheduling would really make much of a difference, I'm a little bit of a skeptic. Let me close on this note, and that'll leave a little bit of time for questions. I hope I haven't gone on too long. I mentioned earlier that my current course is marijuana law and drug policy. So I offloaded all the business practical stuff to my friend who's in the industry, and I get to talk about the Constitution and the like. The reason I'm interested in drug policy, I never realized how quickly people would change their attitudes about drugs other than marijuana. For years, I thought, well, marijuana is the only one with near majority acceptance. Now, medical marijuana is approved by close to 90% or over 90% of Americans, with about 60% favoring recreational marijuana. But in recent years, very recent years, as many of you know, suddenly there is a fascination with other drugs: psilocybin, LSD, MDMA, ketamine, drugs that I never thought would be coming to the forefront. Now, you got to be careful in my marijuana seminar. I had students do some research to try to determine whether people like Michael Pollan, who really are passionate advocates, are overhyping it. I mean, we've had drugs overhyped in the past. drugs like Prozac or a natural product like St. John's worts were supposed to cure depression. But that is another cutting area of drug policy law where I think that the area is going to become booming. You have states like Oregon that have now basically decriminalized possession of drugs like psilocybin and the like. And there is some fascinating research being done into health benefits of LSD and psilocybin. We can thank Timothy Leary for having destroyed the research into LSD back in the 1960s when he famously told young people basically to drop out of society, and LSD became a Schedule I drug as well. Today, we realize that some of the research that was being done was very promising. LSD is very helpful. For example, apparently there's some studies suggesting it is a way to treat alcohol addiction. Anyway, that's the final comment about the way in which I approach drug policy in addition to marijuana law in my course. Mike, any questions out there?
Yeah, we have a number of questions actually. So thank you very much, Professor Patel, that really engaging and informative talk. We are now going to open it up to questions that the audience submitted. Before we do that, if you haven't already done so, please feel free to type any remaining questions into the Q&A window. And Garrett, can you read aloud some of the questions we've received?
Yeah, first up, we have, what is the status of federal laws concerning access to federal banks by quote unquote legal cannabis businesses?
Yeah. Well, it's a complicated question. FinCEN, there are, during the Obama administration, there were some regulations that explain to banks that there are certain circumstances where they can deal with money that has come through the marijuana businesses. The problem is it's quite onerous. It's complicated, and by and large, banks have stayed clear from that. There's a little bit of a misperception in the public that no banking is available. That's not actually quite true, but it's just that most banks have wanted to stay clear from it because it's just too much paperwork. I must say too, that one thing when you look at proposed federal legislation, there are two areas where you keep thinking that business-oriented Republicans and pro-marijuana Democrats could probably come to some kind of agreement and get some legislation passed at the national level. One would be banking, so that you could really have basically ordinary banking rather than this very expensive, hyper-vigilant banking for marijuana businesses. The other is in the area of federal tax law. Reagan era revision, section 280E of the IRS code does not allow marijuana businesses to take ordinary business expenses. That has been a big problem in states like California, where we want businesses to come into the regulated market, because you're making it so expensive for businesses to compete that a lot of black marketeers or gray marketeers are able to sell marijuana product out the back door or just open illegal dispensaries. They don't want to comply with very onerous federal laws. These are a couple areas where you could actually hope for some kind of action at the federal level. Some of us think that Congress is right now so dysfunctional that we're not optimistic that it's going to happen anytime soon, but that would be one area, the two areas where you could hope for some kind of rationality coming out of Washington. I hope I answered the question.
Yeah, that was great. The next one we have here is, can a landlord evict you for violating federal cannabis law, even if it's legal in, say, California?
Well, I have to be very careful about qualifying. Remember when I started off, I said I'm not an nobody's an expert in cannabis law. I'm not an expert in landlord-tenant law, but I would think that the answer would be to look at the lease. And then I will tell you a couple of other things in just a second about how difficult it can be if you're a marijuana user. I can't pretend to be a real estate expert by any means. The first place I would look, though, would be to see the lease. The other thing I should point out that can produce some very cruel results is losing a variety of federal benefits. There are some very cruel cases involving, there's one case involving a grandmother and had a grandchild living in the same home, and the grandchild was involved in marijuana. I forget if use or sale, and there was no showing that grandma knew that the grandchild was involved in using marijuana. And grandma got evicted and lost the litigation in trying to get the government to at least require some showing of some mental awareness that the marijuana was there. So a lot of disabilities in the law, but I just can't. That's an area that, other than thinking the starting place would be to look in the lease itself.
Great, thank you.
But by the way, it does show you something else, back to my earlier point about the business lawyers and guys like me. I'm interested in all this kind of sexy stuff, the Constitution and criminal law. And then there are these really practical people doing the business law, and they're the ones that people seem to be more interested in.
Well, how about this next one here? This one is, some states have state-owned liquor stores.
Yeah.
Was this type of operation considered for California?
Yeah. I don't think, I'm sure that the idea was floated, but it's interesting. Washington State has basically the liquor store model. Look, California is California. One of the things we have, we're trying to figure out how to bring all these legacy people who've been producing marijuana in places like Humboldt County back in the day when I was a young person, and people were going off to live in on the land and rebel against society. We've got so much acreage in marijuana, and one of the goals in California has been to bring these people into the basically regulated legal market. A state store system, I think, would never fly, because you've got people like the legacy people, and then you've got the big business people who want to come in, big weed, and want to come in and do large scale business. So I just don't think it would ever fly in California, because you had too many people interested. If you had to bring them to the table, you had to give them the opportunity to play in the field. And basically a state source system would not have worked, I think, in that. It wouldn't have gotten off the ground.
Okay, thanks. Got another one here. Are Indigenous people, people of color, or formerly incarcerated people given priority to get cannabis business licenses?
The Native American, American Indian question is separate and apart. There's a lot of, and I don't pretend to be expert in that regard. There are a variety of federal regulations dealing with tribes under those circumstances. But let me talk about the minority and former people with criminal records. Well, let me give you a parallel. Let's assume I've got a criminal record and I want to get a liquor license to open a bar. Historically, I would not be allowed to. Well, guess what? We know that the war on drugs has had a terrible racial disparity in arrests and prosecutions and convictions. And so many of us who were interested in seeing marijuana regulated in California wanted the social equity issues addressed. It's tricky. There are some efforts to do so. One, the proposition, Prop 64 itself, does not automatically disqualify someone with a prior record. So if your prior record did not involve crimes of violence, that you could qualify. It's a little bit trickier to try to address the equity issue for this reason. Our current Supreme Court, and it's not just our current Supreme Court, but it's really dating back to the Reagan Supreme Court and certainly the Roberts Supreme Court, really doesn't allow racial preferences. And so if a city like Oakland were simply to come out and say, we're going to give priority to Black applicants, someone could easily challenge that and have that struck down as a violation of equal protection. So what happens is there are workarounds, for example, using zip codes and the like, so that you would get impoverished communities and probably likely to bring in larger numbers of minorities. But it's a tricky business. There are other problems with it too, that's preventing the equity issue from a vigorous solution. There are some cities that really are trying, but one of the bigger problems is the sheer cost of getting into the industry. Former student in my seminar did a paper a couple of years ago, which was published in the Lewis and Clark Law Review. It's a very powerful paper. And she argues that redlining was yet another area where minority communities don't have access to capital, the kind of capital needed to get into the industry. You don't open a business in the marijuana field without some significant access to capital. Just hire a lawyer to do all the licensing before the taxation problems, before the licensing fees and the like. So tough issue. Will we ever get a good equity solution? I don't want to close on a sour note, but it's a lot harder problem than it might seem at first.
Perhaps related, have there been any successful efforts to challenge or regulate marijuana legalization based on environmental impact?
Not that I'm familiar with. In other words, here's how I would be afraid that it might work. Let's assume that you're in a county that wants to allow marijuana production. And someone wants to oppose it by bringing a environmental impact challenge. Again, very technical field that is not my area, but I think it's more likely that the people who would challenge it are the people who oppose marijuana in their neighborhood. I mean, and to be fair to those people, I have some friends who live in one of the outlying counties, and they talk about marijuana production in their neighborhood and the skunky smell and the like, and how it is quite disruptive. But again, we need someone who is really an environmental lawyer. I should mention also, by the way, while we're talking about the environmental concerns, yet another reason why Prop 64 was passed was there are provisions that funnel some money to environmental causes to abate environmental harm done by illegal grows and the like. A legitimate concern, because marijuana, especially in unregulated areas, illegal grows in forests, state and national forests, really have been very detrimental. Uncontrolled chemical use and the like. But Again, whether you could oppose marijuana on environmental grounds, not something I'm familiar with.
Okay, I think we have one last question here. Are there any marijuana plant patents or other intellectual property rights that can be
Oh.
claimed on marijuana or types of branding? And
Yeah,
if so, how does that work?
So again, and this is a highly specialized area. So I'll give you a little bit of a just a glimpse. Very complicated area. Plant patents, very specialized area, and I wouldn't even pretend to be able to answer that question. There have been some local, statewide, for example, trademarks. People have been trying to trademark various marijuana related things at the federal level, and by and large, it has been disallowed. Sometimes you can get a trademark for some product related to marijuana, but not marijuana itself. So you couldn't get a Bob Marley strain of marijuana, for example. But you might be able to get some kind of trademark for some other product related to the field. State laws sometimes have allowed state intellectual property to be developed. But again, it's a highly complicated area, and anyone interested in going into that field would have to really dig deeply. Yeah, as I say, I leave that for my buddy who teaches the business-oriented marijuana course we have.
All right, well, thank you very much, Professor. That was one of the last questions we received, and so this will bring us to the end of the webinar. Thank you again, Professor, for this really wonderful presentation. Thank everyone for attending, really.
Okay.
Yeah, one last thing, Garrett, would you mind just putting those 3 links back in the chat window for people? And then for everyone else, don't forget to sign up for our quarterly newsletter, where you can get updates from the law library. And if you're in the Sacramento area, please visit us in person at 914 Capitol Mall, Monday through Friday. And if you can't visit us in person, you can always reach out to us online via the State Library's website. Before we close, a survey will be emailed out to attendees tomorrow, and we would greatly appreciate it if everyone could fill it out, as it does help us with future programming and events. And thank you all for attending, and have a wonderful evening.
Good night.
Take care. Thank you.